Yeah. All right, so we'll take a quick second here while everyone logs in. So we'll just give everyone a moment or two. All right. I know we're booting up onto the other platforms. We're going to go live on Facebook, I believe LinkedIn, and YouTube as well. So we should have those coming soon.
There you are, George.
All right. There's George. We got plenty of people logging in now. I always like to give it a second or two at the beginning here, give everyone a chance to really get into the room. And while we're doing that, if anyone's on other platforms, you have questions to ask, we're going to try and monitor that, but sometimes it is tough with people sharing it on the different videos. The best way is always going to be to log into the Zoom. You can do that off of mspinitiative.com. If you're already in the Zoom Q&A section, you can utilize that chat box. We'll monitor both those and make sure we save some time for those at the end. All right, so now I'll kick everything off. So first of all, thank you everyone for joining us today for another episode of the MSP Initiative. Very excited to be joined here with our guest this week, Bradley Gross. If anyone's not heard of him before, he has a phenomenal background, especially in our space, which I think is the most important thing. There's a lot of legal advice out there, but I think making sure that somebody who understands your business and understands what you go through on a day-to-day is crucial. So working with Bradley has been awesome, and his firm has been incredible with some of the different vendors and MSPs they've worked with over the years. So our hope here was to answer some of those burning questions that are out there in the industry today and take a little bit of time. So first I'm going to let Brad introduce himself and just kind of go through your background a little bit, maybe some other areas that you've worked with.
Great. Well, there's not a whole lot more to introduce after that. So thanks, Alec. It's always a pleasure working with you guys. Been known George for, God, George, how long has it been? Probably longer than either of us want to admit. We do not hear George. There, now we hear George.
Yeah, I was.
See, you really didn't want to admit it. That's the problem. That's
no. I was gonna say it's IT Nation 2010, maybe. I mean, it's gone back almost a decade.
Could be, yeah, all the way back there. So yeah, but I appreciate that intro. Yeah, we represent MSPs globally. Have counseled or either or actively represent over 1,000 MSPs. So there pretty much won't be an issue that an MSP or a TSP or a solution provider will have that we haven't dealt with, given an opinion on, advised on, and so on. So it's a great space to be in.
Absolutely. And as everyone can see, George is on as well. George Brady is the CEO of VoIP and also CEO of RDC Enterprises, so an MSP out of the Philadelphia area. As you can guess, George and Brad have worked together in the past, but also the cool thing here is, George as an MSP is encountering some of these issues, I think, in the day-to-day, but also has been taking a really active stance as a community member and just being on, honestly, an overwhelming amount of Zoom meetings and happy hours and other things like that. And we're just hearing a lot of the real-life feedback. People are dealing with this every day, and it's a lot of unknown. I know compliance has been a major thing thrown around a lot right now. And, there's one of the biggest questions I think we can kind of kick off on is, we touched on it earlier today, MSAs, are those still good? Should there be changes happening? Maybe that's a good one to kind of kick off with and talk about, should I be looking back at my MSA and editing things today? Or should it just be business as usual and do what you can?
Well,
yeah,
I think
to that point, Brad, let me just expand a little bit. Yeah, so have been in a ton of different groups and kind of collaboration, mastermind type groups, so on and so forth, right? Just day after day, week after week, and there's a lot of different permutations happening. You're talking about people who are deferring payments. You're talking about people trying to add months onto the back end of a deal to kind of give people grace periods now. You're talking about people trying to shift people on the fly, which has primarily been done already, but then how are they, what's the responsibility for the equipment at home that's not, really covered or secured by the MSP? You're talking about, how do I handle force majeure? How do I handle pandemic clauses? Like, there doesn't seem to be a consensus, Brad, but we're not attorneys. That's why we want to hear from you.
Okay, fair enough. So I will give you the consensus. I'll give you the definitive answer. Is that that's the idea? All right. So a couple of things, you know, within your issues, there are a lot of sub issues. There's the MSA, what it should say. There are statements of work, work orders, how closely should they be defined? How much should they be tailored to accommodate the current situation that we're in, right? And moving forward, should we continue to tailor them with the assumption that this kind of thing is going to happen repeatedly? So I guess I'll begin with the MSAs, and should they, you know, your initial question, Alec, about should they be reviewed and how often? Generally speaking, pandemic or no pandemic, MSAs should be reviewed between 3 to 5 years, probably closer to 3, maybe 3 to 4 years. The reason being not so much that the law changes. If your MSA is written correctly and accommodating the legalities that are in place, the law doesn't change that much from year to year to year. What does change, however, are the realities, right? The things that are supposed to be covered in the MSA that go beyond limitation of liability, that go beyond warranties, that go beyond the stuff that attorneys write in big capital letters. What needs to be accommodated and reviewed every 3 to 5 years or so are the realities. Why? Well, you know, 5 years ago, spearfishing wasn't as big a deal as it is today. It was a big deal, but it wasn't as prevalent as it is today, right? A lot of the attacks and malware that we see today, while it existed 5 years ago, it wasn't at the same level. It wasn't at the same veracity. It wasn't at the same intensity that it is today. So for that reason, now you have to say, all right, that's a reality. That's something we're dealing with. We need to accommodate that in our contracts today, right? We're not changing governing law. We're not changing venue. We're changing realities. And that's what we need to accommodate. So the first question that you had about, you know, should it be reviewed? Well, your MSA should be reviewed every 3 to 5 years anyway. And I would suggest that if it hasn't been, then you need to take a look at it and really give some serious thought to having someone review it. That's first.
Perfect.
So in terms of the current climate, Brad, there's a lot of conversation around safety, right? Safety of you, safety of your employees, safety of the customer's employees, uncertainty on, like, there's been guidances and obviously each state seems to be dealing with different things slightly differently, but like what happens in a situation where, you know, on-sites were, you know, part of the MSA or part of the scope of work or part of the material delivery, and now those things are very difficult to do? Okay.
So it's a good question. And it is not only situationally relevant, but it also is something that you need to think about without a pandemic, because bad things can happen. And you need to consider how you're going to protect your workers when that happens. I mean, pandemic aside, what if it's a horrible weather? I mean, like hurricane type stuff, right? There are other things that can happen where you would say, I'm not sending my tech out in these conditions. So I think that anyone who is thinking about that in light of just the pandemic is being a bit short-sighted. I'm not saying you're wrong. I'm saying you're being a bit short-sighted, okay? As far as today, the situation we're in, what can you do, what should you do, and so on? Well, I'm with you. I think that a lot of people have given different opinions about, can you do it? And well, if you're being conservative, you do this, and if you're not being as restrictive, do that. Here's what I think it all boils down to. You're not going to send, and you can't, and you shouldn't send an employee out into an environment where there is a substantial risk, obviously, of death or serious injury. Now, how does that relate to a pandemic? Okay. I am not convinced, and I've done a lot of the reading on this, as well as, you know, like I said, we represent hundreds and hundreds of MSPs actively. And I'll tell you, I am not convinced that the current situation warrants an employee saying to you, I'm not going out. There's a pandemic, I'm scared, I'm not going out. I don't think that the employee generally is going to be entitled to do that at this point. There are some exceptions, right? If you're sending them into an area that is known to be heavily quarantined and you know, it's really from an illness perspective, a really serious problem, that might change the scenario. Similarly, if your employee has a pre-existing condition, right? Perhaps he or she is immunocompromised. Okay, that might give that employee a basis to say, hey, George, hey, you know, whoever the employer is, I can't do this. And that employee would have a very good basis to refrain from acting. Generally speaking, however, I think that if you are going to send your employees out, if you have that type of service level agreement in place, well, and assuming that the person isn't immunocompromised, assuming there's no pre-existing condition and so forth, I think you'd be well advised to do at least two things, right? One, be fully transparent with the employees about the situation, right? Don't just send them into a situation and say, you know, maybe he'll discover they're not sick, or maybe he'll discover they're sick. No, be transparent so everyone is on the same page. Right? We're going to send you to this corporation. No one's there. No one's been there for 2 weeks. There might be 1 or 2 workers walking around, but they were all wearing gloves and masks. I want you to know. Right? So we can make an educated decision. That's one. Two, I would supply them with the PPE. I would give them the protective equipment, masks, gloves. You know, that's what's recommended by the CDC for you and I just to go shopping. So it certainly should be implemented in a workplace type scenario. If you do that, transparency, as well as PPE, and assuming, like I said, no pre-existing conditions and so forth, I think you'll be in good shape.
Absolutely. Yeah, no, I think that's, you know, that's definitely one that's been brought up a lot. I think that factor of, am I required to do the work right now? You know, what if you were under a situation like that where you had something on the books and let's say your law firm or MSP firm in New York, you had something on the books, obviously things have really hit the fan. You know, what am I doing if my client's really still pushing me to get that work done? My clients, you know, my customers or my employees are not feeling comfortable. I'm not feeling comfortable. What's my legal liability at that point?
Well, I don't think at this point you're going to be able to claim that it is an impossibility for you to do the work, right? Impossibility is one of those legal doctrines that basically says if you are unable to do it because it is reasonably impossible. For example, if a state or a locality has locked down an area, you cannot leave, you cannot go in, right? Unless you live there, let's say, that's an impossibility. You simply can't perform the service. That's one thing. Knowing that there's a general pandemic in an area, that's not going to be a legal impossibility, generally speaking. So what do you do? Well, I think that at that point, you have to manage expectations. I have not heard of, I mean, you know, it's sort of like UFOs and Loch Ness Monster. You hear about them. I've never quite seen it, but you hear about it, right? You hear about customers that are crazy. I want you here no matter what. And all right, I've heard, you know, stories, urban legends. Generally speaking, what I have found is that if you manage expectations to your customers, things will be fine. If you say, listen, because of the pandemic, we have a few people who might be immunocompromised. We have a few people who are a bit nervous, so we're going to get them the PPE. We're going to do this subject to technician availability. I'm sure you understand, right? You're probably dealing with that in your own business. So, you know, we're going to make it right. We're going to do whatever we can. We know we're prioritizing your work over others and so forth. If you manage expectations properly, then I have not yet come across a situation where a customer says you're in breach of contract. I have not yet found that. I think it's more urban legend than anything else, but you have to communicate. What MSPs are scared to do sometimes is communicate, and they shouldn't be.
100%. So going along the lines of that, couple targeted questions. Customer is in whatever, hospitality, commercial real estate, whatever. Can't pay their bill. Said they can't pay their bill. Are you then safe to shut their services off, given the current circumstances?
Well, so there are two ways to look at that. There's a contract way and there's what we call common law way, a fancy way of saying we don't have a contract, we don't have a statute, but there's kind of law on this subject anyway. From a contract perspective, look at your MSA. It should describe the situations under which you can suspend services. That is a reality that, again, is not pandemic specific, right? It is not just the case that they can't pay their bill because of a pandemic. They may not be able to pay their bill just because of an economic downturn in general. So first we look to the MSA to see what it says. And if somebody agrees that you can suspend your services for failure to pay or because you didn't receive timely payment, then you could suspend your services. I mean, that's how it is. That's the cold, hard truth. Now, because you have the right to do that doesn't necessarily mean you will do that, right? Just because you have the right to suspend services almost immediately doesn't mean you're going to exercise that right. If I were you, you know, the electric company, for example, has the right, if you don't pay the bill, to turn off your electricity. They can do that, right? I know these days there's a statute, the states say they're not going to do it, but under normal circumstances, they can change. But they don't just turn off your electricity because they know that people are relying on it. So what do? They'll send you one notice, maybe two, maybe three notices, then they'll shut it off. I suggest to everyone listening that you exercise that kind of discretion. Don't just shut someone off because they haven't paid. There might be extenuating circumstances. But can you? If your contract says you can, you can. Now, looking at it from the flip side of the same coin, what if your contract doesn't say that, right? What if your contract does not talk about suspending services for non-payment? All right, well, the general rule is that when one party to a contract doesn't perform, that divests or eliminates the other party's obligation to perform its services. So if one party doesn't pay, right, breaking it down now to plain old, plain English here, you don't pay, then whatever I'm doing that you were supposed to be paying for, I don't have to do that anymore. And it's going to be very difficult for a person or a company that doesn't pay to say, you have put me in a horrible position. You have ruined my business because you shut me down, when they haven't paid, right? You can't do that. You can't use a contract as a sword and a shield. You can't use it as a sword to say, I'm suing you because you shut me down, but then use it as a shield to not pay. So it doesn't work that way. Again, discretion, as they say, is the better part of valor. I would be very, very careful and maybe give 1, 2, 3 different notices before I shut someone off.
Yeah, absolutely.
Another question that came through that kind of revolves around the topic. Can you mandate, so this is Peter Jackson who sent this message in. I'm in New Jersey, we're in the middle of everything. I want to gradually start to return back to the office. Can I mandate that an employee returns back to the office?
Well, unless there is a local regulation or a local statute or of some sort that's been passed relevant to the pandemic, right? You're not going to be able to order an employee to do something that would violate a local regulation. So we begin with that. If there's a local regulation that says you're going to stay at home unless you're a non-essential worker, and if you are a non-essential worker, you have to follow the local government rule. That is a foundational thing. It is. It applies at all times. Now, assume for a moment that doesn't exist. Can you now say to your employees, listen, your job requires you to be here, okay? There is no stay-at-home order that we have to follow. We are going to exercise what the CDC and others are recommending, social distancing, mask, gloves, the whole thing. Yeah, I think that a company probably can turn around and say, I understand you're scared, but fear is not a reason why we're not going to do our business. Again, if the person is sick, if the person wants to take off time pursuant to the Family Medical Leave Act or as it's been amended to accommodate the pandemic, that's different, right? That's different. They have the right to do that. But just generally speaking, if an employer says, I'm opening up again, we're doing social distancing, here's the PPE, there's no regulation preventing this, and you're not exercising your right to take paid time off or unpaid time off under federal law, come on in. Yeah, that's your job. You have to go in. Mm-hmm.
What how does and back to the agreements, I'm bouncing around a few times.
It's all right, I like to bounce around.
Force majeure, does this apply?
Force majeure, is this what?
Does this apply to the pandemic times?
No. No,
Simple
it
as
doesn't.
that.
It doesn't apply. Listen, a force majeure, okay, is largely applied under the doctrine of, again, like I mentioned earlier, impossibility. It means that it is reasonably impossible for us to do the job. Now, again, if you're locked out of an area because the government has the National Guard there saying, if you don't live here and you're not an essential worker, you're not coming in, that's force majeure, of course. But generally speaking, a force majeure, and I've written about this on LinkedIn as well, a force majeure does not exist because of an economic downturn. As a company, you're not going to say, I can't pay you, right? I can't pay you, MSP, because my customers aren't paying me, so that's a force majeure, because I can't control my customers, they're not paying me. That's not a force majeure. That's an economic downturn that people to a contract are supposed to have thought of in advance. Whether they did or not is another story. Same with an MSP. You're not generally going to say, I got a lot of technicians that are scared. I might even have some that are sick, right? And obviously they stay home, obviously, but that means you have a shortage, right? A manpower shortage in that way might not successfully be argued as a force majeure, because the idea is you should have thought of that. You should have planned in advance, right? This pandemic has been so-called, named a pandemic now for what, 6 weeks, 7 weeks? You've had 6 or 7 weeks to figure out a solution. It's going to be very difficult now to say you don't have one, so it makes it impossible. So that's a long-winded way of saying, I don't think under normal circumstances, a pandemic is going to be a force majeure.
Let's talk about, is it reasonable to amend your MSA to now include something around pandemics or viruses?
Is it reasonable? I don't know. I don't think it's, look, everyone's going to react differently to how they're accommodating the current situation. My opinion, you don't modify your MSA right now to be pandemic specific. Why? I mean, wouldn't it be a good idea? Not necessarily, and here's why. One, pandemic's going to end at some point, and your MSA should be both service agnostic and situational agnostic, meaning I don't want you to say that if there's a pandemic, we don't have to perform our services or adhere to our service levels. Why? Because what if it isn't a pandemic, but it's something else that prevents you from acting? Well, now what? Are we going to modify our MSA again to accommodate that new thing? I mean, how many times are we going to modify an MSA? Instead, okay, if you're going to think about this, instead what you should be doing is thinking about including a provision in your MSA that prevents you from having to adhere to a service level for any kind of situation that would expose your workers to a health issue, a safety issue, right? Something like that. Now, it doesn't matter if it's a pandemic. What if it's a tornado in the area? Really, tornado in the area. Okay. That could expose, right? Now we haven't accommodated just a pandemic. Now we've accommodated weather. We've accommodated safety. What if they said that there is, you get to the location and your customer says, "Oh, we need you to move these wires. They're 30 feet up." I'm not going 30 feet up, right? Oh, well, if you have something in your MSA that says we're not going to act if we're exposed to a health or safety, now you're accommodating height. You're accommodating pandemic, you're accommodating tornado. So anybody who says, well, I think you should modify your document to address the pandemic, I think is being short-sighted and probably doesn't understand the industry in a comprehensive way. Again, not an unreasonable thing to do. I just don't think you should be doing it.
Absolutely. Yeah, I mean, so on that topic, right, we talked about the economic downturn and how, that can be hard for a business.
Right.
If it's an unfortunate circumstance, but it is happening out there. If I'm an MSP and I say we're going to have to close shop, what should I be thinking about? We talked about kind of moving forward and how I can keep going with my business, but if my business is going to stop here legally, what are the things I should be looking at? What are the steps I should really take from an employee standpoint, a customer standpoint?
You mean if the MSP is just going to shut down permanently or shut down temporarily?
I mean, we'll tackle both. Still got some time.
Wow. Well, as far as your MSA is concerned, again, this is one of those realities that MSPs need to think about. Again, every MSA, first of all, you need an MSA. If your company doesn't have an MSA, then you're in a boatload of trouble, pandemic, no pandemic, whatever it is. But assume for a moment that you have some semblance of a master agreement. Your master agreement has to think about the end, right? The end of the relationship with the client, the end of a service, the end of something. Everything ends. And the problem is that often it ends not well. So when you're thinking about the end, you may want to think about how do we ramp down? Now, one of the more prevalent things that happens is that an MSP will be in an area or offer a service that it says, I don't want to do this anymore, right? So this is like a temporary shutdown of a service. I don't want to do this service anymore. But we've seen a lot of that with the VoIP. As a matter of fact, they get in over their heads. They realize they should have called VoIP, right? They should have called George. They didn't call George. Now they're in over their head. Okay. So they say, I'm not doing this anymore. Well, what do you do when you have an agreement that says you're doing it for 3 years and 6 months into it, you realize you're over your head, right? Well, I mean, they could hopefully transition to a vendor like George, and maybe there would be a seamless transition. However, if they're trying to get out, what your MSA has to say is, we need a way out. We need a way out. And one of the realities that I think an MSA should talk about is the reality of exiting a service. So your MSA should say something to the effect of, if we stop providing this service generally to all of our customers, we can do that on X amount of time notice, 4 months notice, 3 months notice, whatever it is. And that's not a breach of this agreement, not a breach of the statement of work that we're providing the service under. You need to have exit strategies. And I would, challenge people who are watching this right now, either now or in the future, who have not had someone like me write their agreement, to look in their agreement and see if they have an exit strategy, if they just decide, I don't want to do this anymore. It's too much for me. Probably they don't have that. They should, but they don't. So I would say that exit strategies, whether it is permanent or temporary or service specific, need to be addressed in your MSA. That's how you do it.
Absolutely. No, I love that. I think that's something really important that I don't think enough people probably think about or worry about. We do a lot with the IT Evolve group. And
yeah. They don't think about it. I'll tell you, they don't think about it because in the beginning, we're all friends, right? And everybody, and in your zeal to get the job done, and in your, hey, we closed another deal, we're bringing in another client, it's, X dollars a month and so on. We're all thinking, champagne dreams and caviar thoughts or whatever they used to say on that TV show. That's what they're thinking about, right? But you got to think, have someone like me, maybe with a couple of devil horns on there going, think about the end. It's going to end at some point. And remember, Brad said, often it doesn't end well. And you have to think about that. And even if you have to put that onto your counsel and say, listen, I know we're all friends and we're going to be friends forever. But my counsel, this guy, I know he makes me think about the end. So let's just talk about certain termination provisions, right? And not only ending, right, but what comes before the end? What happens immediately before the end? Answer, transition, right? Mm-hmm. Transition happens before everything is done. If you're not accommodating transitional services in your MSA, you are doing yourself a disservice, you're doing your customer a disservice, and you might as well retain an attorney now because you're going to have a problem. You have to think transition as well. So the end comes in phases, right? It comes down to either either an expiration of a service, 1 year is up, we're leaving, then there's transition and it's over. Or it might come down to sort of a fight. You didn't do this. Well, you didn't pay us. Well, who's right? I don't know. I'm out of here. And still there's a transition and an end. You have to think about these things at the beginning.
So I got a question for you, Brad. With people trying to be flexible as possible, right? Different people are in different financial situations, and some people are strapped a little bit, and some people are in an okay position.
Yeah.
If you run into a customer and they're telling you they're tight on cash for whatever reason, and the cure to that is, I'm going to tack on additional time on the end of the term, if you would.
Okay.
How do you handle that? Is that an addendum? Is that on the back of a napkin? Like what's the policy there?
On the back of a napkin. We've done a lot of deals on back of napkins. I'm not recommending that. So, all right. First, it goes down to, I'm going to start at the foundational level and work my way up. In order to tack on time, all right, you should be tacking on time to a specific project or a specific service. That service should be embodied in a statement of work, okay? In a statement of work. There should be a statement of work that has a definitive time, right? This statement of work is going to go on for X number of months, X number of years, and it's going to cover these specific services. That way, everybody knows what you're amending. What often happens, okay, is that companies will have everything in one big hodgepodge of an MSA SOW, and they'll amend certain parts and not certain parts, and it becomes cumbersome, it becomes confusing. You don't want that. So foundational level, you're going to have a statement of work, and you're going to have an MSA, and the idea is you're going to amend the term or tack on additional time to the statement of work. If you do that, right, then next thing that you have to think about, how do you do that, right? This goes to your question. How do you accomplish that? Can you do it over the phone, right? Can you do it by email? Must it be a formal writing? First thing I would tell you to do, is check your MSA. What does your MSA say? Because if your MSA says we can amend or modify our scope doing it a certain way, then you do it that way. Your MSA should accommodate, in these days and times, email. It should. Any MSA that says, well, we're going to do it by fax needs to be reviewed. We're going to do it by email. Okay. Now, as far as email is concerned, what I would recommend is to ensure that the email is very specific. Because what we tend to see is MSPs enter into a dialogue, and somewhere in that dialogue, they throw around terms and then they agree, and then it becomes ambiguous. Like, what exactly did we agree to? What part? All right. It should be one email. Amendment to statement of work dated whenever. Dear George, this email establishes our understanding, sets forth our understanding that this statement of work dated this is amended as follows. Say exactly how it's amended. Don't put in other things about, in the future, we hope to, no. The amendment, if you agree, please reply to this email with I agree or something to that effect. And once you agree, this amendment will occur and will be effective as of a date listed there, right? If you agree, you send it back, it will be effective as of June 1, or it will be effective on the day that you reply. Put a day in there, right? So you want a specific reference to what you're amending. You only want to put the amendment in that, and then you want a way to capture the affirmation. Once they reply back, you should be good to go. Don't put in extraneous stuff, because that could cause an ambiguity that will cost you a lot in the future.
Does exactly what you just said apply to the freebie? Hey, we're going to give you free remote access services for X amount of time. Same process?
Same process. I mean, ultimately, when you make a free offer in that way, right, as part of an ongoing service, that becomes part of your service, right? Part of the consideration. Mm-hmm. So again, you don't want to throw around things like free this, free that, because even if you then try to recant later or retract it or restrict it, you're going to spend a lot of time explaining what you meant. Right? Your time is worth money. And sometimes you find yourself saying, I just spent 3 hours on the phone because they want this and that. And you end up having to give them even more. And you get project scope creep, right? Because they're asking for more and more. So if I were you, specificity and, amendments and modifications of scope, that's not the time to start talking about your family or talk about how much you're enjoying having them as a customer or how much they love having you. Save that for another email. Changes to scope, amendments, very specific, a specific way to affirm and acknowledge a yes, right? And an effective date. That's what you need.
Absolutely. One thing that's been popping in my head a lot throughout this is, we talked on legacy, we talked on MSA. legacy has been a huge thing in our space for a while now with M&A through the roof. In that sense, do you think that we'll see any changes, or do you think that M&A will keep going on? And furthermore, the MSA, what are the main things if you were at an MSP looking to acquire somebody? What are the main things? There are a couple red flags you can maybe throw out for everyone, or?
Yeah, absolutely. So it's a great question because M&A is going to continue. In fact, I think that you're going to see a sharp upturn in M&A in 2021 at least. So not that it's down now, but you're going to see a sharp upturn then. When we represent an MSP that is acquiring another MSP or any kind of business for that matter, what we look to is to make sure, part of the due diligence is that the MSP that is being acquired is actually run like a company, right? That it's not all hype, that it's not having a couple of good years and they say, see, look how much money we're making, you want us, all right? There has to be obviously a strategic reason for taking over another company, but assuming for a moment you have that, whether it's to expand your technical ability, whether it's to expand your geographic presence, right? A lot of different reasons for whether it's to eliminate a competitor, right? Sometimes you buy your competitor to eliminate your competitor. Great. What you need to do, okay, what we look for, and I'm recommending every MSP do it, is follow what I call the foundational 5, okay? It's the 5 categories of things that every MSP needs to have. And if it doesn't have these things, then when it is looking to be acquired, it's going to run into a lot of obstacles. You're going to run into a lot of dead ends because acquiring companies want to see these things. Now, what are they? 1, you need to have contracts in place. This whole handshake, well, we do things on invoice. We've known our customers for 20 years. They've stayed with us. That's fine, but we're all friends until we're not friends, right? And then they may not stay with you. Or when we buy you, they may not stay with us, right? So you need to have contracts, MSAs, and statements of work. 2 categories of things you need to have. The third category of things that you need to have are corporate documents. Every MSP here is a company, or I hope you're a company. You shouldn't be doing it as an individual. You're a company, you're an Inc., you're an LLC, right? So you need to have a shareholders agreement. You need to have an operating agreement. You need to have these things. If you don't run your company as a business, no one else is going to treat it as a business. No one's going to want to acquire something that's run like something other than a business, okay? Governing documents. 4th category of things that you need, employment agreements, employee handbooks. You want to run your company like a business? Well, then treat your employees like it's a business. Okay, make sure that your employees are bound under employment agreements, restrictive covenants if you need them. Make sure that your policies are laid out in employee handbooks, social media, privacy in the workplace, all kinds of things, right? Drug testing, all that stuff needs to be laid out in a handbook that the employees are required to follow. 5th category of things, contractor agreements, independent or subcontractor. Very few MSPs do everything by themselves. They often sub this stuff out. Maybe they're going to do the BDR, RMM work by themselves, but maybe they'll do some low voltage cabling or something like that. They're going to sub that out. Well, you want to make sure that your subcontractors are held to certain standards because I promise you, your customers are holding you to those standards. So hold your contractors to that. And if you go to foundational5.com, www.foundational5.com, you'll see a survey there. We could have a consult. In fact, one of the things that I'll do for you guys for having me on today is offer a free consult. We could talk more about that at the end, but go to foundational5.com and you'll see the type of questions that you should be thinking about, and you could register for a consult there as well.
Absolutely, and thank you for that. That's a really kind offer. So I hope some people take the time. I mean, it's absolutely worth it. We just put the URL over there in the chat box, so take a look, and we'll make sure it gets onto the other platforms as well. George, what do you have there?
Active pandemic times, and then we've got some questions rolling through. I want to make sure we get those in there.
Okay.
Absolutely.
One on the fly comment, since it's just right after your comment. Peter Jackson says, you didn't mention verified financials, but I guess financials probably have something to do with M&A.
Well, of course. I mean, I'm not saying that when we look to the due diligence that we only look for contracts and say that's it. Right. You're going to look at the verified financials. You're going to look at the tax returns. You're going to look at a whole bunch of things. But what I'm saying from an MSP perspective, something that MSPs can control right now, today. They don't need an accountant. You know, they don't need to say, well, my accountant is still auditing this or whatever it is. What they can control right now is an MSA. That's under your control. Either you're going to have a crappy MSA, no MSA, or something that's solid where an acquiring company can look at you and go, oh, okay, you've protected yourself legally. You've protected yourself from the realities. That's good. Statements of work. This is what we provide to our clients. Well, what prevents scope creep? Because we have a solid statement of work, right? You can do that. Corporate documents are within your control. Employee agreements within your control, as are contracting agreements, you know, independent and subcontractor. The rest, of course, is very important. You need to have financials, obviously. You need to have bank accounts and so on. But I want every MSP right now to think about the foundational 5 and realize they can do these things right now and change the world in which they're operating.
So
Love that.
Shifting gears on you real quick, because this is really what I was after. Okay, you shifted people to work from home.
Yes.
You know, you gave them access to the VPN or the remote desktop or the SharePoint or the Dropbox, whatever it is. Am I now taking liability on the home computer they're signing in from?
Great question. Well, first of all, yeah, I've read a couple of things online about how, you know, some pundits are out there saying, you know, just adjust your MSA to say that we'll move you to your house if we have to, or that's, you know, that's what we're going to do. Okay. No. Again, you don't want to be pandemic specific. That's one. Everything should be negotiated on a situational basis. You don't just assume that a pandemic will occur, so we're going to write it for that. That's first. Second of all, your contracts need to make clear what you're doing because you're obligated to do, what you are doing as an accommodation. If you cannot make that clear, if that clarity doesn't exist in your contract, don't do it. Don't do it, because you're going to find yourself getting a call at 3 in the morning from your customer because his daughter's printer isn't working, and he thinks it has to do with the fact that you distributed the workforce and now it took down their home network. And now you find yourself fixing, you know, a home network which has 3 Vista machines on it, you know, and it's just not worth it. So the idea here is that if you're going to move to a distributed workforce, work from home, WFH, right? What you're going to do is you're going to make it very clear what you will do, what is an accommodation that you're going to do on your best efforts, but there are no guarantees about the outcome. You're also going to want to make it very clear that there's simply certain equipment that you cannot support. Best efforts only, right? Level 1 support. What's level 1? Password help, right? Installation, basic functionality. Anything more than that, if they don't have a support agreement, even for their home device, you're not covering it. Otherwise, you're going to take on a lot more than you bargained for.
Absolutely.
Mm-hmm.
So we have a bunch of questions flowing through. I'm going to scroll back up to the top a little bit so we can start hitting some of these. So first one, we actually had Josh say that he has had several times he's had to refuse on-sites in April. So it looks like those customers are out there. So that's disheartening. But it sounds like everything works out. So
Josh has refused to go on-site. Is that what he said?
Mm-hmm.
And that's okay. I think that, again, if you explain to the customer why, maybe it's technician availability, it could be fear. I think a lot of people will understand that. As long as you look like you're acting reasonably and you're not acting irrationally, like I said, I've yet to see a case in which a customer has turned around and sued or threatened to sue. Urban legend. Really, it's urban legend.
Absolutely. He said it didn't lead to any disputes, but it did. He worries it will weaken some relationships. So hopefully he'll be able to get those in the right case and keep everything moving forward.
Right.
Let's see. Here's one from Keith. They own the IP for several systems, i.e. ILWU, worker dispatch, watchman dispatch, etc. Our customer agreements are specific that we own the code and the port, and the ports lease the software as part of our system management. Okay. Should we include transferable language?
transferable language as far as owning because they own everything. And they're saying at the end, should you talk about transferring? Yeah, I definitely, you know where this comes into play as well? When you're providing an IP address, and you guys probably know about that as well in the VoIP situation, where you own IP addresses, where you own numbers and so forth. What are you going to transfer? What are you not? Not only should that be addressed in the contract about transferability, in the transition, remember I said that earlier, transition, think about the end, right? But I think that you need to make that very clear, abundantly clear in the statement of work in which you're providing those services, because customers don't understand it. We understand it. You guys understand it, right? Everyone listening to this probably gets it, but the customers don't. What do you mean I don't have I have to, what do you mean my IP address that I've been leasing that? I've been renting it? What do you mean this phone number is your number? It's not mine. It's on all my business cards, right? We can't port this. You have to make that very clear in the statement of work. Ownership and transferability. So yes, I think not only should that be accommodated, it should be accommodated and clarified in very plain language. So there's no mismanaged expectation. Mismanaged expectation is when you end up calling an attorney and it costs you.
Absolutely. So we did have one that came through, and this is something I've heard a couple times in a couple different groups, so I'm happy it was asked. So it was asked about someone had a problem with an employee before the pandemic. So not very happy with the relationship, and it's gotten worse as this person worked from home. If they were going to terminate, would there be any extra steps, documentation that they should really think about with the current environment?
Yeah, it's a problem, right? Because, you know, whoever wrote that, you're not alone. A lot of companies are facing the same situation where they had an employee, the employee just isn't doing the job, and then something like this happens, and now the employee's even worse. And then if you're going to terminate them, the employee is going to turn around and find some bottom feeder lawyer who does wage and hour work, who's going to say, oh, you know, you fired him because he asked for overtime, or you fired them because of a disability. And, you know, and that's simply not the case. That's simply not the case, right? Okay, let's begin at the beginning. You cannot and should not, underline, cannot and underline should not ever terminate someone because of a disability. You need to accommodate that person, and that's what you should be doing. Hard stop. Okay, assume for a moment the person is just simply unable to do the job, right? Unable to do the job because they're just not competent, right? He or she is just not competent to do the job. Well, what you need to be doing is you need to be documenting that. And I don't care if you document it without telling the employee, with telling the employee. I'd recommend with telling the employee, right? You need to document it. You need to show a pattern. Because if you don't show a pattern, it's going to look like you are picking and choosing, and you're maybe engaging in some sort of wrongful termination. You need to have that backup. Unfortunately, right, companies find themselves without that backup, and now the pandemic hits, and this person's really awful. Well, you know, it's like one of those things that if you're going to terminate an employee, make sure you have a job-specific reason for doing it. Job specific. It is illegal to terminate someone based on obviously race, sex, religion, disability, and that is, like I said, hard stop. It is not illegal and not improper to terminate someone for not doing the job they're supposed to do. But make sure you can document why they haven't done the job. If you haven't documented it all along, make sure you can document why they haven't done the job, and you should be okay.
Absolutely. So we just had another one that came through. So this gentleman's been using their MSA that contains the statement of work. For you, is it better to have those separate? Will the MSA be the contract, or do they need a separate document too?
Oh, this is my mantra. I mean, you've just hit, you just picked up the guitar and just strummed the chord that I always sing to. C sharp, by the way. So here's the deal. MSA is your constitution. It is service agnostic, and it does not change. It is your constitution. It is service agnostic. Am I on camera here? Yeah. Service agnostic constitution does not change. Okay. You cannot have a statement of work in your MSA. Why? You cannot list services in your MSA. Why? because then it's not service agnostic. And then your MSA cannot adhere to rule number 3. It does not change because your services change. You might have a precious metal plan, a gold, a silver, a platinum, whatever it is, right? Project work. If you put that into your MSA, then you're changing your MSA. Your MSA should not change. So what you need to do is you have your MSA that sits on a throne. It does not change. It is governing everything you do. And then what you need to do is take your services, your deliverables, and put them in one or more statements of work. Each statement of work is not, underscore, not a contract. If your statement of work is labeled managed service agreement, or it begins with, this contract is between, then it sucks. It's awful, okay? It just stinks. What you need to do is you need to think about a statement of work as just what we're gonna do, how we're gonna do it, and how much we're gonna charge for it, okay? Every statement of work needs to reference the MSA, right? Needs to reference it and say, hey, we're governed under that, but here's what we're gonna do for you, right? I'm gonna make you a pizza, I'm gonna deliver it to your house in 30 minutes, it's gonna be $15 or it's free. That's my statement of work, right? You and I, we could sell that, as I tell people all the time, we could sell that all day long. You know, companies have done that, right?
Yeah, absolutely.
You know, if we said, I'm gonna sell you a pizza, 30 minutes or it's free, $15 to your door, but before you order, I need to talk to you about arbitration, and there is a prevailing party, and by the way, there's this indemnification thing that you need to understand, right? People are gonna say, I don't want pizza anymore. I don't want that, right? You don't want to keep shoving the MSA in front of a client. You can't sell an MSA. You can't sell an MSA, but you can sell a statement of work pretty easily, right? So you don't want to change your MSA. That sits on the throne. Statement of work is a separate deliverable document. That's the way you should be doing it. If you're doing it any other way, it's no good. That's right. It's no good.
Love it. All right, George, any more questions on your side?
Yeah. So,
What are the Jets' chances this year over the Eagles, George? Do you want to go at it? I mean, I'll go at it with you.
Zero.
Well, the Jets over the Eagles, yeah, probably zero, but I'll still go at it with you.
All right.
I'm a former New Yorker, so it's fine.
Hey, man, just because you're in Florida doesn't mean that, you know what I'm saying? Should there be different MSAs for different service, different levels of service? That one just came in and it kind of
No, there's only one MSA. You have one agreement. If you have different levels of service, then you have different statements of work that describe your levels, but you do not have different MSAs. You have one MSA. That's it.
Okay, a lot of MSA
And then we
questions.
Good, let's do it.
How do you present an MSA then if it's separate to a SOW?
How do you present it? There are a couple of ways you could do it. You can have someone sign it, and once they sign it, they put it away in a drawer and they never have to look at it again. That's one way, and that's perfectly fine. And I'm not, by the way, advocating one way over the other. Any of these are fine. You can have them sign it physically. You could have them sign it electronically, right, through any sort of electronic signature or electronic acceptance mechanism, whatever it is. You could incorporate it by reference. Ooh, that's the big one, right? Incorporating by reference, where they don't ever actually have to sign the MSA. Never actually have to sign it. But what they're doing is they're signing a document that's specifically, expressly, clearly, conspicuously, I'm going to think of some other adverbs, you need to point out that the MSA is located somewhere and that they should look at it. And if they can't access it or they need a copy, ask for it before signing your statement of work, and you reference it in your statement of work. That's another way to enforce an MSA.
A lot of
it really depends on your level of tolerance and you know, what you're willing to do and what your business operations allow you to do.
I call a lot of handcuff questions tied right to this. If you send a second proposal to someone, do you not also include the MSA again?
God, I hope you don't. Jeez, because if you send a second proposal and your MSA talks about limitation of liability and waivers and realities and so forth, good percentage of the time, now it's going to be kicked up to their legal department. They're going to want to negotiate it, and you don't negotiate your MSA. So why would you keep throwing it in front of them? And that's part of the problem with including it as one big hodgepodge. Once they sign your MSA, that continues as long as the statement of work is in progress, right? So what you're going to do real fast is the answer is no. Assuming your MSA is written in the MSA SOW paradigm correctly, SOW, not the MSA for each new proposal.
Right along those terms. So are you implying that the MSA only needs to be signed once? The answer is yes. So if it's signed just once, every time you go through a contract renewal, right? You're at the end of your 1 year, your 3 year, whatever the term is. Aren't you not representing the MSA for agreeing and now into the new term?
Oh, God, no. You are not representing your MSA because you're not negotiating your contract. See, again, whoever asked the question, respectfully, I don't know who it is, you might not see what I'm trying to say about the MSA is your contract. It's your only contract. Your service, what you're providing, is a deliverable. You can renew your deliverable. You're not renewing the contract, right? So your deliverable, your statement of work will say, this statement of work, for this statement of work, I'm going to lift up this soda can every 10 seconds for a year, okay, for a year. And at the end of a year, I will renew, or you can renew, or it'll automatically renew this statement of work. Each statement of work is separate. I'm not renewing my master agreement. My master agreement was signed. It's governed under what I'm doing here under the master agreement, but you're not renewing your agreement. You're renewing your deliverable, your statement of work. That's the paradigm that you really need to follow.
So there's two questions that fit right into each other. I'm going to both them together. So are you saying that the scope of work, the statement of work by itself is a legal document, and then following that, if the MSA is the actual contract, how can you say that it doesn't need to be signed, or how are you saying incorporate by reference?
Okay, so couple of things. You can incorporate a document by, wait, I want to address one at a time, right? Your first question related to statement of work.
Is the statement of work actually its own legal document?
No, it's not it is not a legal document in that it is not a separate contract. It is governed under your legal doctrine, right? It's governed under your agreement, and it is an enforceable set of rules that everyone's going to abide by. I'm going to pay you $10. You're going to paint my wall, right? That's in that statement of work. Well, I paid you $10. You didn't paint my wall. Well, right. That's enforceable, right? But you're enforcing it under your master agreement. Your statement of work is just a deliverable description. That's all it is. Now, in your deliverable description, you can say, not only is this governed under the master agreement, by accepting this deliverable, this description, you are accepting, in very clear language, it has to be clear, unambiguous, right? You are accepting the master terms located at www.whatever.com. And if you don't want to accept them, then you should not sign this document here, which describes what we're going to do for you. It's called incorporation by reference. It's done all the time. If it's done properly, it's enforceable. I wouldn't go it alone. You know, I wouldn't just simply say, oh, you know, I'm going to just write something at the top that says, we're incorporating this document by reference, and then continue. You may or may not be able to enforce it at that point. But generally speaking, the paradigm works. It's an MSA SOW paradigm, and you can incorporate things by reference. They sign the statement of work, by the way. Statement of work has to be, something has to be signed, right? They sign the statement of work incorporating the master agreements.
So following again, same logic. Then changes to the MSA would just be emailed to the client as an addendum? I think there's maybe a confusion there.
Well, so how do you change the MSA if you need to, right? So let's say your MSA says, generally speaking, okay, you're not going to touch your system without my permission. That's my MSA. You're not touching your managed environment unless Brad says so. Okay. Now I go into an environment with a that's co-managed. You have your own IT department. Of course you're going to touch your system. And if you think we're going to call Brad every time, well, you're nuts. We can't do that. But your MSA says, don't touch it unless Brad says so. What do you do? Two things. One, your MSA should specifically talk about the fact that a statement of work that differs from your agreement, the statement of work will control. Because the statement of work is the most recent version, the most recent, here I'll talk tech, the most recent iteration, okay, of the party's agreement, of the party's thoughts. You know, agreement like on the same wavelength, not contract agreement. It is the most current version of what's going to happen. So where do you make these changes? You make them in the statement of work. Statement of work dated April 30th, 2020. I am going to change the light bulb in George's house, and I'm going to monitor and maintain that light bulb. For the purposes of this statement of work, George is also allowed to monitor, maintain, and change the light bulb as he may choose from time to time. Here's the thing, George, if you change the light bulb and you mess things up, I don't have to fix it. I only have to fix things I did, but we can co-manage, but if you mess it up, it's on you, right? Now what happens? Well, you haven't modified your MSA. Your MSA still sits on that throne, and it says you don't change it unless Brad says so. So what happens is you don't get different versions of your MSA, and different people have different versions. You have one version. But you can accommodate George's need in this case by saying, oh, all right, in this particular co-managed environment, George can do what he has to do. I have to do what I have to do. We've described it in the statement of work. And by the way, if you screw something up, George, that's on you. And now we've accommodated everyone's needs.
So more questions on this very topic. Shouldn't
all right,
I will take one more.
All right.
I'll go all day. Who says that? Like Captain America? I'll do this all day. Go ahead.
Should an MSA be included as a link, i.e. checkbox to agree with link to MSA in each client quote? But
I think that's probably a great practice. Yeah. Yeah. So should the MSA be referenced in each client quote? Absolutely. If it's not referenced, then theoretically they could say it's not part of this deal. This was a separate deal. Your MSA has to govern every quote, every statement of work you give out. Now you can do that by clearly acknowledging that it's done. If you have a checkbox that says, by checking here, I recognize these terms, or I've read them, or I voluntarily decided not to. Beautiful. I love it. That's all good. If you want to, I would recommend that checkbox not come pre-checked if you're going to do that. But other than that, yeah, I like that idea. Anything where you can have your customer sort of affirmatively know and understand that there are terms out there. Yeah, absolutely. That's what you want to do. That's what you want to do.
Awesome. Yeah, we've had some good ones there. We had one more that came through actually on the chat side. So this is the statement of work only. Shouldn't the MSA make reference to the fact that it can be amended by the SOW in force at the time?
No, you don't want to amend your MSA through your SOW. You're not amending it. You're modifying a deliverable, okay, that might differ from the language in the MSA. But you don't want to modify your MSA through your statement of work, because what if you have 7 statements of work, right? Remember, what if number 2 modifies the MSA? Then numbers 3, 4, 5, 6, and 7 all now have to follow that modification. That's crazy talk. Your MSA does not get amended through a statement of work. Your statement of work can modify a deliverable, can modify a service level, can modify what your MSA says for the purposes of that statement of work only. Now, if you ever come across a time when you need to modify the MSA, I mean your master, this is your constitution, all right? Think of it like our own US Constitution. We don't amend that so easily, right? But if you're going to amend it, then you do an amendment between the parties to the MSA. And realize that's global. That's now going to affect every statement of work you have, right? Every one. So I would recommend refraining to the greatest extent possible of modifying your MSA. I would do it through the statement of work.
There was a question earlier that I was circling back to. You mentioned common law related to customers who are not paying.
Yes.
In addition to the contract MSA terms. However, I don't think you really described how common law works. Can you expand on common law?
Oh my goodness. Wow. Well, first of all, now I'm having a little I'm post-traumatic stress, right? PTSD, going back to law school. So now I have to call my therapist. So George, you now owe me $150 for that session. I'm just letting you know. Just letting you know. It was a question. I'm in a happy place though. Okay. So we'll see. We'll see. Maybe he'll give me a discount. Here's the deal. All right. What is common law? Without getting too much into the weeds of the law. Okay. You have statutes. right? Statutes say you can do something, you cannot do something. That's what we usually regard as the law, right? What is the law? Okay, but statutes don't cover everything, right? Statutes just don't cover everything in the world. I mean, if I if I break a contract with you, is there a statute on the books that says you will not break contracts? No, you're not going to find a statute out there that says you can't break a contract. So what makes it, what protects people from having people break contracts? Well, there is a whole subset of the law that is not embodied in a regulation or in a statute, right? Or in the Constitution. What it is it's set up by cases that have been handled over now hundreds of years, going back to Old England and Blackstone law. And so that we've said, generally speaking, this is what should be, right? If two parties have a contract and one party doesn't act, well, then the other party doesn't have to act. It's not a statute. It's case law that's been developed by the court system over hundreds of years. That is what we call common law. It is common to the land. It is common to how we act. If I said, well, show me in the statutes where it says that, I can't. But I could show you about 10,000 cases over the past 100 years that say that. That's common law.
We had a good one recently, Brad, about a contract being a contract if it wasn't specifically signed. If you remember.
Right, we did. Yes, we did. Now you need therapy. Okay.
Trust me, everybody who knows me thinks that already. What steps should be taken if you actually need to change your MSA globally, right? Like maybe there needs to be a modification in the Constitution. Then
yeah. So it's a great question, but unilateral changes to an MSA, and when can you do it and when can't you do it? Well, there are a couple of things that you can do, all right? If your MSA specifically says that you can unilaterally change it, then you can do so, all right? But there are usually qualifiers. There are qualifiers. For example, look at the credit card industry, okay? They change their master agreement all the time. And what they do is they say, in their agreement, it says, we can do this. We can change it unilaterally by giving you notice of the change. However, you have an exit strategy, Mr. Customer. If you don't like our change, stop using the card, pay us what you owe us, and you're out of the, there's no more contract between us. So as long as there is an exit strategy or consideration on both sides, you'll be okay, right? A company can't just turn around and say, I'm changing my contract. I know I didn't have the right to do it. It doesn't say I can. There can't be a unilateral change without an ability to do it. You could put it in your contract that says you have the ability to change. You can negotiate that with your client. I want to change my MSA. I'm going to give you another 6 months if you agree to these changes. You could do that, right? Now, what do you do if none of that happens? Here's how you change your MSA. You either, you change it obviously for incoming new clients, that's easy, or old clients, you wait for a natural touch point. A natural point at which you are going to be reaching out to them. For example, a renewal, right? A renewal. You know a renewal is coming up in December. The parties have the right to terminate with, let's say, 30 days notice. Otherwise, it automatically renews, okay? 4 months before, you send them something. Listen, our general counsel was going through our documents. We noticed that you're not operating under the latest version of our MSA. We require harmony, uniformity, this and that, and so on. So here's a copy of the MSA. This MSA, we're going to ask you to sign it. It will be effective for the renewal, okay? Sign here. You've given yourself a lot of leeway now, right? You've given yourself a couple of months to reach out to that customer to see if they're willing to sign it or not. If they sign it, great. If it's written correctly, then on that renewal, your new MSA kicks in. If they don't sign it, well, then you have a choice to make, don't you? Right? You either continue under your old version of the MSA, whatever that might be, or you be sure to terminate your relationship with that client. That's your choice. That's a business decision you make. But you can't just unilaterally turn around and say, I'm changing it. That's the way it is. That doesn't fly.
3 more unless anything else pops in. 1, my customer doesn't pay me, and I then can't in turn pay for my SaaS services, right? So My vendor then comes to me and says, I'm shutting you down for non-payment. Am I now liable for my customer services? But like, if you follow the cookie crumble, though, it started off with the customer didn't pay,
Right.
therefore you can't afford to pay, therefore now your vendor shutting off services.
George, you just passed your first year of law school. That's exactly right. If your customer doesn't pay, well, then he or she has violated the terms, divests you of the need to fulfill your terms. So that's that. Yeah, that's the way it is.
Cool.
Mm-hmm.
There's a question here about, I don't know if this is maybe touching the law or not, but how should I market my MSP specifically for post-pandemic opportunities?
Wow. How do you market it for that? We just did a whole dialogue conference on that a day or two ago about marketing for post-pandemic. And, the message that came across from our marketing experts, Mark S.A. Smith and Dave Lorenzo, they both kind of, said the same thing in different, they approached it in different ways, came to the same conclusion. You don't market your company for post-pandemic. You market your company. That's what you do. Anyone who is marketing to say post-pandemic is missing the boat. Okay. It's all about relationships. It's all about touching out, reaching that customer, giving that customer something in these times that he or she really wants. It might be some free advice. It might be an extra perk. It might be give them something now while they're suffering, while they're hurting, because when they come out of this, they're going to remember that. Okay. It's about the relationship. So the short answer to that is you don't market for post-pandemic, you market. Hard stop right there.
Last question, Brad,
Absolutely.
and then we'll let you talk about your offer. If you're offering somebody something free, right? Free advice, free consulting. Hey, I'm gonna hook you up because you're in a hard time and we just want to give you an hand.
Mm-hmm.
Should that be done under an agreement, even if there's no dollars exchanged?
Yep.
Or are you just doing it free will here?
Absolutely. No, everything that's free, okay, should be that you're offering should be done under an agreement. Now, here's why. Because you can mess something up regardless of how much you're being paid, right? You could say, look, we're going to do a free network audit, right? A free network audit, let you know what's going on your network. And you walk in and you mess something up. I don't know. You knock over a candle, it burns up the server. You install some sort of inventory software, and at that moment, that's the moment a cryptovirus hits. You had nothing to do with it, but that's the moment a virus hits. And you know what they're going to do, right? What did you do? What did you do to my system? You could be replacing a toner cartridge. If the system goes down, they're going to say, I don't know. You touched my printer, and now I don't have a backup system anymore, right? I mean, so it's not about the scope of the work. It's not about how much you're offering or what you're charging. It is about reducing liability, and every MSP should be doing things under an MSA, and that is the way it should be.
Absolutely. We did have just a comment come through. Richard said Bradley needs his own talk show. He's very good. And one thing I want to touch on there is you have your own podcast, correct?
I do. Yes, I do. As a matter of fact, it's Technology Bradcast. So instead of podcast, it's Bradcast. Yes, I'm very clever in that way. TechnologyBradcast.com. And also, we just started our own conference series called Dialogue. We had one 2 days ago. We're going to have them in the future. It's called Dialogue, the Unconference, right? Unconference, meaning that there are no real set questions or topics. It's just all over the place. Whatever's on your mind, we're going to talk about. So sort of like what we're doing here. So there's that. And yeah, I enjoy it. So thank you. Thank you for that.
No, of course.
It was a compliment from the.
Well, it's definitely a compliment. And yeah, I mean, I remember George actually went in there a couple weeks ago. I love the format of it. So everyone make sure, jump over to the website, take a look at that. And obviously we've got your website right behind you. So if anybody needs any legal advice in the future, I mean, we had an unprecedented amount of questions coming through. So I'm sure that people think of more as people are watching it.
They can reach out to us. I mean, that's okay. Like I said, I appreciate you guys having us on this podcast, or this webcast, I should say. But like I said, we do have an offer. In fact, here, I'm going to show it on the screen if that works for you. Hang on.
Absolutely.
Let me see if I could do that. Let me see.
There we go.
Is it on? No.
Yep.
It's on.
See it.
Is it on? I don't know. I don't see it anymore. So what do you guys see? I'm assuming that
free consultation with Brad Gross.
Brad Gross, there it is. Okay, it is on your screen. I was just a little slow to find it. Yeah, let them reach out to us. Mention this, all right? So when you email it to info@bradleygross.com so we can keep track of where things are coming from. Include your name, company, title, phone number. Mention this webcast, MSP Initiative webcast. You can, if you put down something like Philadelphia Eagles stink, that's okay too. Sorry, George, I love you. You know I love you, right? Okay, I just had to throw that in there, and then look for a reply from us, and we'll set it up. All right.
I argue I have the best starting and secondary quarterback in the league.
I'm not going to challenge you because, in truth, you know far more about it than I do. I'm just a unfrozen caveman lawyer. I don't know, so it's fine. But yeah, I really appreciate you guys having me on, and I hope that everyone takes advantage of that. Because I think it's a good thing. So here, I'm going to let him take another screenshot of that, and we're good to go. So
awesome.
I was just going to say, if you could actually, I'll make sure that our team touches base with you after this and just grabs this quick info if they haven't grabbed a screenshot yet. And we'll make sure this gets out to everybody in a reply to this. We'll have this live and we'll have this on demand. So, as always, if you didn't catch the full thing, go back, watch the on demand. It's available. We have tons of great information. I feel like we could take any of these 3-minute snippets of answers and build all of them into their own webinars. So Brad, as always,
part 2 might have to come up, George. Part 2.
Hey, Brad, you're always welcome. You're always welcome, Brad. We didn't even get to have the back and forth that we usually like because there's just questions.
We didn't. Well, hopefully soon.
All right, stay in touch, and thanks everybody for watching. And remember, we do these webinars twice a week. I'm stealing Alex's tagline, Tuesdays and Thursdays. So make sure to keep on the regular interval, and you'll see these topics come up. And we're just trying to help educate the masses.
So on that, one last final piece, we are going to do our next one on Tuesday, May 5th at 1 p.m. We're having Paul Azad join us from Service Tree. Great operation out of Australia. If you've not heard of them yet, take a look. But he's going to be joining us to talk about how to ensure working from home is a win-win for your team and your MSP. So definitely a hot topic. He's got a great operational brain, so I'm sure he'll have some good information for us there. So make sure to register or join us back here at 1 p.m. on Tuesday. And again, as always, Brad, thank you very much. Look forward to scheduling the next one with you. And
thanks.
Stay safe out there.
Hey, you too.
Thanks, everyone.
All right, take care.